क्यों? Why next week? This is the MCC. Your appeal has been dismissed for want of prosecution. You have filed the application for restoration of the appeal. Why next week? Restoration के लिए तो next week क्यों? लिखना मिस्टर क्या शुभ नाम लिखते हैं? मिस्टर SP साहू appearing on behalf of Mr. राज अवस्थी, Learned Counsel for the appellant. किसके लिए अपेयर हो रहे हैं आप? किसके लिए अपेयर हो रहा है? आपको ये भी नहीं मालूम किसके लिए अपेयर हो रहा है? कौन सा केस है, क्या है, किसके लिए अपेयर हो रहे हैं? कुछ नहीं मालूम, बस खड़े हो गए नेक्स्ट वीक। पासवर्ड करने से
Item 3, Shri Sumit Singh, AG.
Item 3. May I please, Mills?
Yes.
Mills, the petitioner here is aggrieved by the order
Yes.
passed by the authorities, which is absolutely non-speaking and unreasoned order. Mills can straight away come to the impugned order, which starts at page 16.
Page 16.
Yes, Mills.
Yes.
Mills can see, in fact, after the show cause notice, I had filed a detailed reply along with the annexures. I'll come to that in a little while. If Malas will see the order which they have passed, it says the fourth paragraph. If I may be permitted to read, I'll just read this paragraph. Page 6. It says, व्यवसायी की ओर से कोई भी अधिकृत प्रतिनिधि उपस्थित नहीं हुए और उनके द्वारा आवक जावक में कुछ वांछित दस्तावेज जानकारी प्रस्तुत किया गया है, लेकिन DRC 01 से संबंधित उल्लेखनीय बिंदुओं पर रिप्लाई एवं डॉक्यूमेंट प्रस्तुत नहीं किया गया, which is absolutely untrue. I'll show from the records. Can you have a look at page 46 and 54?
Yes.
54 is my detailed reply which I had filed.
Page 46.
Page 46 is prior to show cause notice, and page 49 is the reply which I had filed, which has given rise to this impugned order.
Yes.
Annexure P7, page 48, and then page 49, the reply starts. So whatever discrepancies, my lords, the department had pointed out, like for example, excess claim of ITC or mismatch of value of supplies or mismatch of outward supplies, I have given detailed reply. And if page 54, there was a detailed annexures which was filed to show the discrepancies, which is at page 54. Index of annexures to form GST DRC 06. Yes. I have given all details, every reply. So at least the authority should have considered the reply, seen the annexures, and then come to a conclusion. Simply saying that I have not filed any reply and I have not given any documents, and then passing a non-speaking order is completely in violation of natural justice. So the petitioner is aggrieved by this order, minutes.
Yes, Mr. Gary.
But this reply is in response to the show cause notice under section 73 of the Act.
Is there any other remedy of appeal?
This is an appealable order under section 107.
107.
Yes, ma'am.
Allah's only difficulty
before the tribunal.
Yes, my lord. No, my lord, before the assistant commissioner, because ये 73 का order है, 107 में deputy commissioner का order pass किया गया.
After depositing 10%, 20%.
Yes,
10%.
10%.
Yes, madam. Why don't you have filed the appeal?
I'll tell Malas. Malas, the only difficulty is if Malas will see the order. If I have to file an appeal, I have to at least give reason. What is the reason against which I'll file? And I'll show in the case of SIS only, this petitioner, Malas, in fact, their department has been issuing notices and passing orders without giving any reason. And everywhere in the country, Malas, this order has been quashed. What I'm praying, I'm only praying, let the matter go back. Let them consider my reply, give me a hearing and pass an order. Then whatever order is passed, Malas, I'll comply with that. That's the only limited prayer I'm asking today.
In that case, my lord, I'll have to seek instructions and file reply.
And in fact, I filed a compilation of cases to show that in such circumstances, all the High Court's mallards.
How much time you will take, Mr. Gary?
About 2 weeks.
Let reply come. Let reply come.
Mallards, till that date, they should not take any coercive actions against me.
Let the reply come.
Well, there's no coercive action till that date.
No, no, no,
That's
please,
the only limited
no.
prayer I'm asking. My lords.
Let reply come, I will decide the matter.
Well, as I'm praying for, that's the reason, my lords, if that can be considered, at least my learned friend can give an oral assurance.
You deposit 10% of the amount.
My lords, if that, my lords, the only, that's what I'm saying. If I'm the only prayer which I'm asking is, let the matter, if my lords can have a look at the compilation which my colleague has filed.
I will stay if you deposit 10% of the demanded amount.
Well, as if the matter has to go back and they have to consider my reply, and after reply, then let the reason order be passed.
If ultimately you will succeed, you will get back your amount.
My lords are fully aware the way department functions. To get back even ₹1 is most difficult thing.
You have an alternative remedy of appeal.
My lords, there is no alternative. My lords, there is no alternative remedy. There is a complete violation of natural justice. In fact, no hearing has been given to me. No reply has been considered.
Sorry. Either you deposit 10% of the amount or let the reply come.
My lord, let the reply come in. I'll come back in after 2 weeks. Let the reply come.
May I know your good name, please?
My lords, I'm Kavita Jha.
Miss Kavita
Senior
Jha.
advocate, my lords. Yes.
Miss Kavita Jha, senior advocate, through virtual mode, along with Miss, what is it?
Shami Kapoor.
Vaisali Jaiswal. Vaisali Jaiswani, learned counsel for the petitioner. Mr. Gary Mukhopadhyay, government advocate for the respondents. Both the respondents, na?
Yes, Farah.
Next, learned counsel for the respondents prays and is granted 2 weeks time to file reply in the matter. List this case immediately after 2 weeks.
Grateful, my lords.
Grateful. Yes. Pastor, कौन सा है? हाँ ले लो.
This to cause for case. Item 2. Shri Rajavasti, Shri C.R. Sahu, Shri A.S. Rajput.
लिखना none for the applicant in 2 rounds. List this case after 3 weeks.
This to mention case. Item 10 and 11. Shri Manju Sinha, Dr. Karan Pandey, Shri Ashutosh Pandey, AG.
Yes, Mr.
Your Lordship, may just at the moment, let me just briefly.
Both these petitions are arising out of the same ECIR.
Yeah, that's
Same ECIR.
that's right.
About 2 different accused persons.
That's correct. That's,
Common order. There is only one order which is.
Only common order.
yes,
Challenged by the accused person separately.
that's correct. That's correct.
Yes.
Just, Your Lordship, may just leave everything for the moment. Let me in 5-7 minutes tell your
Yes,
Lordships what the issue is. The issue is a purely legal issue.
Yes.
Whereas on the 31st of August, 2023, whereas the Enforcement Directorate issued a summons, knowing full well that the person against whom they've issued the summons is in Australia. One second. On the 1st of September, they issue a summons. They know that he is in Australia. And whereas they ask him,
Summoned to the present petitioners.
that's correct. They ask him to appear on the 2nd. Whereas he is a citizen of Vanuatu. And whereas the Australian authorities detain him at immigration. Right? So he can't appear in any case before the ED on the 2nd. Then they issue him a summons that he should appear on the 4th. On the 2nd itself, that you appear on the 4th. Can't appear on the 4th. Thereafter, Malaj,
Have you informed the authorities that I am in Australia and this is the problem?
they know about it. They admit it.
Okay.
It's an admitted position. What I'm telling you are admitted positions.
Yes.
So, Malaj, he can't possibly come. Thereafter, they move Malaj under section 70 of the Code of Criminal Procedure and pass an order against me under section 70. Now, my lords, the question that arises for your lordship's consideration is, one, when a summons is issued, and these are poor questions of fact, law, my lords, we're not going to go into fact because this is not a quashing petition. The question for your lordship's decision is that if a summons is issued by the ED, it can be issued to an accused or it can be issued to any other person. The PMLA prescribes procedures that have to be followed if a person is issued a summons who's not an accused and a person who's issued a summons who's an accused. And those procedures are set out in PMLA itself. I will demonstrate to your lordships, my lords, that they have not followed those procedures because PMLA is a code in itself. The Code of Criminal Procedure does not apply, and the whole proceedings are null and void. This is the only question of law that, my lords, that is to be argued. Now, my lords, just a bit about the PMLA. My lords, the PMLA deals with two kinds of offenses. One, what is called a predicate offense. That is, supposing I cheat somebody, then if it is part of the schedule of the PMLA, it is a predicate offense. And on the basis of that, the Enforcement Directorate can lodge what is called an ECIR and proceed under this act. Now, the proceeds from the predicate offense, for example, you cheat somebody 10 lakhs of rupees, those become proceeds of crime. And if you take those proceeds of crime and seek legitimation of those proceeds of crime by putting it in a bank and something like that, then you are trying to show something that is illegal as legal. And therefore, that is money laundering. It's like you put dirty clothes in a washing machine and they come out clean. So your dirty money comes out clean by your taking steps to ensure that it is legitimate money. So that is money laundering. So, my lords, there are original FIRs filed in this case where I was not shown as an accused. That is, neither of us was shown as an accused. My lords, then these proceedings took place and an ECIR was lodged.
In which ECIR your name appears?
This present ECIR.
First, second, third. In which ECIR?
No, there is no first. That's a summons, my lords.
Achha, there is.
We are not at the moment, my lords, at that. Now, my lords, even a complaint has been filed. So that's a separate issue. I am only, my lords, on the procedure adopted under the code. That's the only.
Section 70.
That's a pure question of law, my lords, and nothing to do with the facts. Because as and when the facts come, my lords, we'll file a quashing petition or whatever. That's a separate matter, my lords. At the moment, I am residing in Dubai, my lords. And the case essentially is, my lords, that I run what is called a Mahadev book or a Mahadev app platform. Now, on the basis of that platform, there are certain panel operators. In other words, my lords, people can play games. They can play game cricket, they can tennis, or they can play poker, they say. So people who are panel operators in India seek access to my platform. And they get players to play that game. And the allegation against me is that when the players play that game, that is gambling. So a predicate offense has been committed, correct? And the proceeds that emerge from playing that game, or which a certain portion allegedly is attributed to me, is money laundering.
Yes.
Right? So this is essentially the case in a nutshell, my lords, and we can go through it, but that's not relevant for our purposes.
Yes.
So, my lords, the Enforcement Directorate can then, in the course of their investigation, with respect to not proceeds of crime, because that's investigated by the investigating agency, they are only dealing with money laundering. So when they are entitled to seek summons, proceed against an individual, ask him to appear. And that is under section 50 of the PMLA, where you can summon anybody.
Yes.
Now, the section 50 doesn't make a distinction between an accused and a person who is not an accused. It makes no distinction. So, my lords, when a person is summoned under section 50, he doesn't know in what capacity he is being summoned. Right, my lords? Then, if he doesn't answer the summons, then the consequences of his not answering the summons, if he is not an accused, are set out in section 63 of PMLA. The consequences of an accused not answering the summons is set out under section 59. Correct?
Yes.
PMLA is a complete code in itself.
Yeah.
So if the consequences of non-compliance of summons are set out in the Act and the procedure to be adopted for non-compliance is set out in the Act, there is no need to go to the Code of Criminal Procedure. And therefore, these all proceedings are illegal. This is the short point. Now, let's kindly come to section 50
Then PML.
of PML. Yeah, please. Yeah.
$59.
50.
Yes.
The title is Powers of Authorities
Yes.
regarding summons, production of documents, and to give evidence.
Yes.
The director shall, for the purposes of section 13, just mark that, have the same powers that are vested in a civil court under the Code of Civil Procedure while trying a suit in respect of the following matters, namely, discovery and inspection, enforcing an attendance of any person, including any officer of a reporting entity, and
Yes.
examining him on oath. Kindly mark the expression reporting entity. Compelling the production of records, receiving evidence on affidavits, issuing commissions for examination of witnesses and documents,
Yes.
and any other matter which may be prescribed. Now, what is section 13? Let's go back to it. Let's go to section 13. So 50 subsection 1 deals with section 13. Section 13 says powers of director to impose fine. The director may either on his own motion or on an application made by any authority, officer or person, make such inquiry or cause such inquiry to be made as he thinks fit to be necessary with regard to the obligations of the reporting authority under this chapter. There was a mention of reporting authority under 13?
Yes.
Under section 50 subsection 1?
Yes.
So these proceedings under 50 subsection 1 deal with reporting authority. Correct? Now, if at any stage of inquiry or any other proceeding before him, the director, having regard to the nature and complexity of the case, is of opinion that it is necessary to do so, he may direct the concerned reporting authority to get its records as may be specified, audited by an accountant from amongst a panel of accountants maintained by the central government for this purpose. And the expenses of and incidental to any audit under subsection 1A shall be borne by the central government. If the director, in the course of any inquiry, finds that a reporting authority or its designated director on the board or any of its employees has failed to comply with the obligations under this chapter, then without prejudice to any other action that may be taken under any other provisions of this Act, he may issue a warning, direct the reporting authority or its designated director on the board or any of its employees to comply with the instructions, direct such reporting authority or its designated director on the board or any of its employees to send reports at such interval as may be prescribed, by an order impose a monetary penalty. So section 13 is directed towards a reporting authority, and section 50 subsection 1 deals with issuing summons to a reporting authority, right? Now kindly see the definition of reporting authority that's set out here. And you will find that it's at 2 subsection WA, reporting entity.
Yes.
Reporting entity means a banking company, financial institution, intermediary, or a person carrying on a designated business or profession. Right, Malaj? Why is section 13 like that? Because if you're going to launder money, you will have to do it either through a broker,
Yes.
or a businessman, a professional dealing with money, or through the bank. So Section 13 says that if we get suspicion that somebody who has proceeds of crime and is laundering it, then the reporting authority may be called and asked to produce evidence, produce the documents, produce the bank statement, produce the ledger entry, right? So the purpose of 50 subsection 1 is to send a summons to a member of a reporting entity and seek evidence in that regard. So that's the scheme of section 50 subsection 1. Now let's go back to section 50. Then the subsection 50 subsection 2. The director, additional director, joint director, deputy director, or assistant director shall have power to summon any person whose attendance he considers necessary, whether to give evidence or to produce any records during the course of any investigation or proceeding under this Act. Now, this is beyond reporting authority. The ED can ask anybody, any person, right? For the purposes of an investigation or proceeding under this Act. Now, when I argued the case in Vijay Madanlal Chaudhary, I indicated that the expression here is investigation. Investigation is an expression relates to criminal investigation. And therefore, this expression must be so interpreted. The court rejected that argument.
Any investigation or proceeding under this Act.
Correct. So the court said the investigation is also a proceeding. The court rejected my argument. Yes. That matter is before a special bench on the 18th of this month, the review of that matter, but that's another matter. All the persons so summoned shall be bound to attend in person or through authorized agents, as such officer may direct, and shall be bound to state the truth upon any subject respecting which they are examined, or make statements and produce such documents as may be required. So, this is for everybody, not the reporting authority. Yes. Then every proceeding under subsection 2 and 3 shall be deemed to be a judicial proceeding. Under section within the meaning of 193. So, if I do not state the truth, then I am liable to be prosecuted. So, because it's not an investigation, because I am not an accused, I am still bound to state the truth. I don't know in what capacity I am being called. But this argument of mine that there's a distinction between investigation and inquiry rejected by Supreme Court. Correct, So therefore, section 50, they can summon anybody to appear and give evidence and to make a statement which must be truthful. Right?
Yes.
Now, this is the scheme of section 50. So a summons was issued to me under section 50. Not as a reporting authority, but under 52, 50 subsection 2, right, and I did not appear. Let's assume that the summons have been served and I did not appear. Yes. I'll assume that for a moment. Yes. My argument is going to be that summons is bad in law, but that's just another matter. Kindly now see 63. May I read 63?
Yes.
Any person willfully and maliciously giving false information and so causing an arrest or a search to be made under this Act shall on conviction be liable for imprisonment for a term which may extend to 2 years or with fine which may extend to 50,000 rupees or both. So this is when you make a statement which is false, this is the consequence. Now see 2. If any person skip A and B,
yes.
Because A deals with being legally bound to state the truth, and he refuses to answer questions. So that stage hasn't arisen. And refuses to sign any statement, that stage hasn't arisen. C applies. To whom a summon is issued under section 50. Lordship sees that? Either to attend to give evidence or produce books of account or other documents at a certain place and time, omits to attend or produce books of account or documents at the place or time, he shall pay by way of penalty a sum which shall be not less than 500 rupees, but which may extend to 10,000 rupees for each such default or failure. So, my lords, if I don't appear, willfully don't appear, then this is the consequence. Then subsection 3. No order under this section shall be passed by an authority referred to in subsection 2 unless the person on whom the penalty is imposed, proposed to be imposed, is given an opportunity of being heard in the matter by such authority. That's subsection 2. That stage hasn't arisen. Then subsection 3, this is 4 now. Notwithstanding anything contained in clause C. Clause C is to whom a summon is issued, which I read to your lordship. Notwithstanding anything contained in clause C of subsection 2, a person who intentionally disobeys any direction issued under section 50 shall also be liable to be proceeded under section 174. In other words, apart from paying fine and 10,000 rupees a day, I am also liable to be proceeded under 174 of the penal code. Correct, Merz? Now, what does 174 of the penal code say?
You mean to say that the consequences are civil in nature?
Yes,
The
exactly.
consequences are the civil in nature.
No,
If you have not complied with that correction
Correct.
in the summons,
Yes. No, and also it is also criminal in nature because 174, if you see 174, whoever being legally bound to attend in person or by an agent to a certain place and time in obedience to a summons, notice, order, or proclamation proceeding from any public servant legally competent as such public servant to issue the same, intentionally omits to attend at that place or time, or departs from the place where he is bound to attend before the time at which it is lawful for him to depart, such shall be punished with simple imprisonment for a term which may extend to 1 month, or with fine which may extend to 500 rupees. So the consequence, I'm now taking a case where I willfully do not attend pursuant to the summons issued to me. What's the consequence? 174. That's in the PMLA itself. So how do you go under the Code of Criminal Procedure? You can't.
yes.
Now, Madhaj, now let's assume that I am an accused now. I'm not talking about a person who is not an accused. Now let's assume I am an accused because I can only be summoned in 2 capacities. Either as an accused or a person who is not an accused. Now, in that context, look at section 59. Now, the problem with 59,
Yes.
that this summons is to be issued by the court. So 63 deals with the summon issued by the ED. 59 deals with the summon issued by the court. Correct, Madhaj? Now, let's see what happens when a summon is issued by the court. But in this case, Madhaj, that's not happened. Not in these proceedings. Now, what does it say? Where a special court in relation to an offense punishable under section 4, now, Madhaj, I am sought to be prosecuted under section 3 and 4 of the PML. So, where a special court in relation to an offense punished under section 4 desires that a summons to an accused person or a warrant for arrest of an accused person or a summons to any person requiring him to attend and produce a document or other thing, or to produce a document or other thing, or to produce it, or a search warrant issued by it shall be served or executed at any place in any contracting state. It shall send such summons or warrant in duplicate in such form to such court, judge or magistrate through such authorities as the central government may by notification specify in this behalf, and that court, judge or magistrate, as the case may be, shall cause the same to be executed. So the scheme is very simple. If I am not in India, as your lordship knows, Malaj, no summons can be issued to a person who is not located in India. Because the jurisdiction of the court is circumscribed by the jurisdiction first of the police station, local police station, and an accused is outside the local police station within the territory of India.
What does the contracting state means?
Contracting state means where we have a treaty.
Treaty. Yes.
Right? That treaty, Malads, is the procedure to, and these are reciprocal obligations, Malads, under the treaty, now, through which I can be extradited. So if I, for example, Malads, I am located outside India, I've committed an offense in India. What will happen is, Malads, a summons will go, if it's a summons, it will go through the Home Ministry, and there is a memorandum which says what the procedure will be to be adopted. It will go through the Home Ministry. But Malads, if I am an accused, and they are seeking my arrest, that will go through the External Affairs Ministry. And it will be served through the mission wherever we are located. And India has missions all over. And that mission through the court of appropriate jurisdiction will then serve me. And then I'll be served. And then I have to abide by the law. So therefore, when it comes to an accused and a court order of the special court under the PMLA, then, Malads, the procedure under the Code of Criminal Procedure is 105, but under PMLA, it's 59. So if it's not an offense under the PMLA and it's an offense under the Code of Criminal Procedure, then 105 will apply. But since it's a PMLA offense, 59 applies. And those memorandums of the Government of India would be applicable, as I presently show. So it says, it shall be served or executed at any place in any contracting state. It shall send such summons or warrant in duplicate in such form to such court or judge or magistrate through such authorities as the central government may by notification specify in this behalf, and that court, judge or magistrate, as the case may be, shall cause the same to be executed. Right, Malads? Now, in the facts of this case, which are the admitted facts, I'm not in India. Correct? At the time when the summons was issued on the 1st of September, I was in Australia.
By what mode you have served the summons? Served with the summons?
Pasted at my residence.
You are not in India.
No, they pasted at my residence.
Pasted at the residence.
At the residence. At the local residence. Knowing full well whether I'm not here. That can't be done as a matter of law. So much as they know I can't appear on the 2nd. It's just not possible. I am detained by the Australian immigration authorities and sent back to Dubai. Then they issue a summons on the 2nd, say come on the 4th. This is a pure mala fide exercise of power. And I'll tell your Lordship why, and presently I'll tell your Lordship why. So one, it's a procedure outside this act that they have followed. Now, how can they go to sections? Now read section 70 of the Code of Criminal Procedure. That's the application they file under section 70.
CRPC.
Now, first of all, Malads, section 70 doesn't deal with arrest. It deals with the form of warrant of arrest, not the power to arrest. It says, every warrant of arrest issued by a court under this code shall be in writing, signed by the presiding officer of such court, and shall bear the seal of the court. How does an application lie under 70 for my arrest? 70 is only the form of arrest, Maharaj. The reason is they don't want to follow the procedure under 63. Well, 63 is the procedure under the PMLA. And Maharaj, Vijay Madan Lal Chaudhary has held that if there is a procedure under the PMLA itself for service of summons, then the Code of Criminal Procedure will not apply. There is no other way of serving summons. That summons can only be issued by the court. As I've shown in the 59, which is this, Marat, I showed your lordships that. Under the guidelines of the central government, I'll come to those guidelines, but I'm broadly, Marat, telling your lordship what this case is about. Right, Marat? So therefore, no application under 70 would lie. No order can be passed under section 70.
Yes.
So, Marat, the submission before your lordship is that the order passed by the magistrate on an application under section 70 of the code is void. There is no authority of law for the ED to move that application under section 70. And there is no authority of the magistrate to order my arrest. Because the arrest is being ordered because I have not obeyed the summons. Not for anything else. That I have not joined the investigation. They know that if they issue me a summons on the first, I can't join the investigation on the second. They know that. That's ex facie unreasonable. They know that if they issue me a summons on the second, I can't join on the fourth. They know that. They know I'm in Australia. Yet they do it. Why? Because they don't want to follow 63. So it's a mala fide exercise of power, not in factual terms, but a legal mala fide. Malice in law. Not malice in fact, but malice in law. So they can't adopt this procedure under the code when they have a procedure which is set out in the PMLA itself. And even if they were to adopt the procedure in court, for my arrest, if I am outside the territory of India, they have to follow 59. For a summons, they have to follow 59. And that also through a court. ED can't summon me. And section 70 is not the repository of the power to arrest. So no application can be moved under 70. So Maharaj, these are the broad parameters of the legal submissions that I'm going to make. Therefore, Maharaj, I just wanted to succinctly mention it as I move forward. Now I'll, Maharaj, take your lordships to the facts. Maharaj, kindly, let's look at their application under 70. Page 90. Page 91 of my lords.
Simple notice to person served under Article 14.
That's correct. This is 70 application, that's correct. And it says 70 of the code read with 65 of the Prevention of Corruption Act.
Where do you reading?
Well, it's right on top, the highlighted portion.
Page 91, na?
Page 91.
91.
Yes.
Simple notice to person served under Article 14.
In Saurabh Chandra, Maharaj. Saurabh Chandrakar petition, I'm sorry. Then maybe
Mr. Sipal, it is 93. Just add 2 pages. I think my lord has page 93. Your pagination is not correct, Mr. Sipal.
Okay.
Just add 2 pages.
As long as I'm incorrect in my pagination, I'm very happy.
In my turn, I will. In my turn, I'll show more incorrect.
I know that. You're
My application under section 70.
Lawyer.
Yes.
My learned friend is a very, very competent lawyer, so he will certainly show to your lordship. Now, let's kindly see application under 70,
Yes.
read with section 65. Would my lords also look at 65? Why do they say 65 of the PMLA? Yeah. My lord has 65?
Yes.
It says, the provisions of the Code of Criminal Procedure shall apply insofar as they are not inconsistent with the provisions of this Act. So it's in my favor. Because the provisions of this act for non-compliance of summons of the ED is section 63. So the code will not apply. So how are they filing an application under 65? With the provisions of this act to arrest, search, seizure, attachment, confiscation, investigation, prosecution, and all other proceedings under this act. Now, while we are at 65, kindly look at chapter 5 of this act. Chapter 5 starts from section 16. Now, if you look at the heading, you will find summons, searches, and seizures. Does you see that heading? But if you look at section 16, it starts with power to survey. There's nothing to do with summons. Then section 17 is search and seizure.
Yes.
Nothing to do with summons. Section 18 is search of persons. Nothing to do with summons. Section 19 is power to arrest. Nothing to do with summons. Section 20 is retention of property. Nothing to do with summons. Section 21 is retention of records. 22 is presumption as to records of property in certain cases. And then presumption of in interconnected transactions and burden of proof.
Yes.
No provision on summons. Though the heading is summons searches. Why? Because 50 subsection 1 has that procedure. Right?
Yes.
And 50 subsection 1 is a summons issued by the ED to any person they want. And the consequence of non-compliance is 63. And 65 says, to the extent there are provisions in this act, right, inconsistent with the Code of Criminal Procedure, this act will apply. The Code of Criminal Procedure, you can't summon a person if he is not in India. In fact, he is a citizen of another country. I don't even know whether the section 59 applies or not, for the reason that's not an issue today. But the reason is the following. Mulats, there has to be a contracting state. If I am a citizen of Vanuatu, and there is no treaty with Vanuatu, then Mulats, how do they, and I have to be a citizen of India. Kindly see, a citizen of India does an offense outside India. Courts in India have jurisdiction over that citizen. But if he is outside India, by virtue of the fact that courts have jurisdiction over that person, you can call that person. And how do you call him? Through the treaty, pursuant to which you will have to follow the guidelines of the central government and serve him through a court there. And then once he is served, because he is your citizen, you are entitled to prosecute him. Right? At the moment, he is not even your citizen, but in this case, that's not necessary. That question only arises, Mullahs, when because in this case, the complaint has been filed. So that question will arise in another proceeding. But that's another matter, Mullahs. At the moment, we're only concerned with an ED summons, where section 63 is not followed, and a section 70 application, which I just was reading before your lordships. I've digressed because it talked of 65.
Yes.
I just wanted to mention that, your lordship. Let's read this. Whereas they talk about raid being conducted. We're not concerned with any of this. During course of investigation, it was gathered that various FIRs have been filed. These are FIRs against other persons. I'm not an accused in these FIRs. Then they discover about Mahadev book and the app that is being operated upon. And then paragraph B at page 97. 99. 99. Okay. Paragraph B, Madam. Para A and B, I can read both.
Yes.
It says Mahadev Online Book provides online platform for the illegal betting and different live games like poker, card games, chance
Paragraph
games.
D you were reading, na?
A.
Paragraph A.
Page 97.
97. It's all right. That's why I said 97. You said 99. I was saying 97. You said
Paragraph
99.
A.
Yes,
Yes.
I was right. That's all I was saying. Because my friend taught me that these pages are 2 pages
This
ahead.
is in the pages.
Yes. So this Mahadev Online Book provides online platforms for illegal betting and different live games like poker, card games, chance games, betting on cricket, badminton, tennis, football, and also provides facility for playing a number of card games like Teen Patti, poker, Dragon Tiger, virtual cricket games using cards, or even apps allowing placing bets on different elections in India. The betting app is operated by various panel branches. This is their case, Marat, which are sold by Saurabh Chandrakar and Ravi Uppal like a small franchise, but they keep nearly 80% of the profit of the panel operations. A panel has an owner and workers who are usually 4 in number. One person can own multiple panels. The main office is being operated by Saurabh Chandrakar and Ravi Uppal in Dubai, commonly referred to as HO or head office by panel owners. Head office creates profile for the panel owner who can further create user profile of players, punters. Panel operators allotted fixed credits, which it can transfer. This is the nature of the enterprise. Now kindly come to the last paragraph at page 98. Last 3 lines. The main accused, your Lordship has that? At page 98?
Yeah.
The main accused, namely Saurabh Chandrakar and Ravi Uppal, who are sitting abroad. So the Section 70 application admits that they are sitting abroad. Are out of the reach of the Indian Law Enforcement Agency. Right, Madhu? So an application is filed under Section 70, knowing that they are sitting abroad. With respect to what? A summons issued. A summons issued when in Australia. Issued on the 1st to appear on the 2nd, issued on the 2nd to appear on the 4th, and then a Section 70 application. Section 70 application has absolutely no relationship to the court of to the criminal courts in India having jurisdiction. Now let's read further. Then the rest is again on facts. Then kindly come to page 100, paragraph 8. Your Lordship has asked me, how do they know that we were rejected? Yes. It's an answer to that. I told your Lordship that's the admitted position. Para 8. On 31st of August, intelligence was gathered that Ravi Uppal and Saurabh Chandrakar have been detained in Australia. So much as they knew that I'm in Australia. And yet they issued me a summons on the 1st to appear on the 2nd. Knowing full well that it's not possible for me to appear. So this was a farce. A reply has been received from Australian High Commission that it has been gathered that Ravi Uppal and Saurabh Chandrakar have been detained, have Vanuatu passport, so they know that I'm not a citizen. Your Lordship knows that under Indian law, you can't have dual citizenship. If you have acquired the citizenship of another country, you lose your Indian status. So you're not an Indian citizen.
Dual citizenship?
Not allowed.
Can it not be?
Not allowed in Indian law.
Yes.
Under Indian law, it's not allowed. You can't acquire. But what happens in some countries is that you're born in those countries. So you're born a citizen. So that's not an acquisition.
Yes.
So to that extent, you may. But then once you're 18, you can then choose. But otherwise, Mala's dual citizenship not allowed.
Yeah.
In some countries it is, but in India it's not. So Mala's admittedly, I'm not an Indian citizen. So they know about it. They obtained Australian visa on the basis of Vanuatu passport. The Australian Immigration Department has cancelled the visa held by these two individuals, and they were taken into immigration detention pending removal from Australia. So they know that I can't move from there. They are aware of the fact that I cannot move from there. That I will be, in fact, sent back to Dubai. Because, Mullahs, I've got a visa for Australia. So I'll be sent back to Dubai. So they know that I cannot be there, and yet they issue me a summons fully well knowing that I can't possibly come, but I am under detention. That's why malice in law. They know it. And they use that as an excuse to proceed under the code, which also they can't do. Nothing prevents them, Mullahs, from them issuing a summons to me through the court. What prevents them? And I tell your lordships why I'm saying this. Because now they want to take law into their own hands. But I'll show that to your lordship, but that's in a minute.
Yes.
The Australian Immigration Department has cancelled the visa held by these two individuals, and they were taken into immigration detention pending removal from Australia. It was also gathered that they are still holding Indian passport. The details of the passport are as follows. Right, Mullahs?
Yes.
It is submitted that as the respondent's presence is required for collecting crucial evidence, and also all the necessary information in the personal and exclusive knowledge of Saurabh Chandrakar and Ravi Uppal, they both were summoned under 50 to appear on 2nd September, summoned issued on the 1st, and then again on 4th September. The said summons was served as per due process of law at their last known addresses. The summons issued to Ravi Uppal were served on 2 different addresses of him. However, neither the respondents nor their representatives apprised of their inability to appear before the investigating officer of the Directorate of Enforcement. Hence, they have failed to appear to tender their statement and also did not submit any response to the summons. This non-cooperative attitude of theirs justifies the issuance of a non-bailable warrant against the respondents to ensure that the respondents submit to the process of law in India. But that process of law in India, to submit to that process, is required to be done in terms of 59 through a court. Through a court order. And 59, the procedure to be adopted is with the contracting state through the Ministry of Home Affairs for summons and through the Ministry of External Affairs for arrest. So how is it non-cooperative if on the 1st you ask me to appear on the 2nd? Obviously, this is false. Ex facie false. How can I not be cooperating when I'm under detention and you issue me a summons to appear on the next day? It's a 16-hour flight, Mullahs, here, but of course, I'm in detention, so there's no question of catching the flight. I'll be repatriated, Mullahs, to Dubai, not here. So, that's correct. But that they'll give you immediately. That's not if you land in India, they'll give you that visa. But that's another matter. Relates to operation of illegal betting app website involving huge
India is
funds.
not on the position that on arrival visa is to be granted.
No, it can be, Mullahs, because
On arrival.
if they want, Mullahs, this, your lordship knows that the authorities in India have the discretion to grant a visa. It's not that. So they can, because they'll need me, Mullahs, they can say. Well, that is to facilitate their own design. Anyway, the respondents have deliberately been evading proceedings under PMLA. Mullahs, how can that be? This is the first time that a notice is sent to me on the 1st. How can I be deliberately evading proceedings under PMLA? So 2 statements here are ex facie false. One, that I am not cooperating, and that I am deliberately evading. This becomes the reason for a warrant. That from the above, it is evident that the conduct of the respondent is non-cooperative towards the investigation, and they will not appear before the investigating authority in the present investigation unless they are compelled by law to do so. Then says Code of Criminal Procedure, the provisions of the code shall apply insofar they are not inconsistent with the provisions of this act to arrest, search, attachment. I read that. I read 60. I read 65 to your lordship's mother, and I read also the chapter 5. That in view of the foregoing facts and circumstances of the case, which reflects utter disregard to the laws of the land by Mr. Saurabh Chandrakar and Ravi Uppal, it is humbly prayed that an open-ended, non-bailable warrant may please be issued against the aforementioned respondents under section 65, read with 70. It is not section 70 read with 65. It is 65. 65 has no relationship to the issue of a warrant of arrest. An open-ended, non-bailable warrant. 65 has no application. 65 says if there is inconsistency, the PMLA will apply. These provisions will apply. These provisions are 63. 63 doesn't give you any power for a non-bailable open-ended warrant. Prayer is ex facie, mother, inconsistent with the legal procedures etched in the PMLA itself, part of the PMLA. 2, the non-bailable warrant so issued may please be direct, but this is really shocking, please be directed to be executed through officers of the Directorate of Enforcement in accordance with law. This order can't be executed through the Directorate of Enforcement. Directorate of Enforcement has no jurisdiction to execute these orders. Both prayers, Maharaj, are ex facie, beyond the law, contrary to the law, inconsistent with the law. This is like, Maharaj, when the US wanted to get some persons from Bolivia or some of these drug people, Maharaj, they used to fly the plane there, pick them up and bring them. How does the Director of Enforcement get this power, Maharaj?
When this application was filed?
On 4th itself.
4/9.
Yes, that's everything. When I was to appear, Maharaj, according to them. So on the 1st, they say 2nd. On the 2nd, they say 4th. On 4th, they file the application. On 4th, they get the order. And they say this is a power under 65. So, Maharaj, this happens. Now see, Maharaj, what order that is. What is the order that is passed? Page 49. Right? Just one, let me just make sure. 45?
44, page number 44.
No, this one, page 49. Now, this is very interesting orders. Whereas Saurabh Chandrakar, Joseph has that?
Yes.
And Rameshwar Prasad Chandrakar, son of so-and-so, aged that, is about 28 years old. Chhattisgarh is required for committing the offense. What does that mean? Required for committing the offense in 3 and 4 of the Prevention of Money Laundering Act in the ECIR bearing number so-and-so, you are hereby directed to arrest the said Chandrakar and produce him. How does the ED get the power to arrest a man, Maharaj, who is outside the territory of this country? Now look at it, the top, Maharaj, section 70, 71, and 72 of the code. What is 70, 71 and 72 of the codes? 70 I've shown to your lordships. Seventy-one is power to direct security to be taken. And 72 is warrants to whom directed. A warrant of arrest shall ordinarily be directed to one or more police officers, but the court issuing such a warrant may, if its immediate execution is necessary and no police officer is immediately available, direct it or any other person or persons, and such person or persons shall execute the same. Obviously, this is meant for persons who are available in India. So how does the Director of Enforcement, knowing that the person is not in India, ask to execute the order? There's no such law, Malaz, which he can do it. Now, Malaz, not that this is an issue here, but it's interesting to read section 73 with me. The Chief Judicial Magistrate or a magistrate of the first class may direct a warrant to any person within his local jurisdiction. So, Malaz, the scheme of the court is very simple. You can only direct arrest of a person through a police officer within the local jurisdiction of which you reside. The Chief Judicial Magistrate or a magistrate of the first class may direct a warrant to any person within his local jurisdiction for the arrest of any escaped convict, proclaimed offender, or of any person who is accused of a non-bailable offense and is evading arrest within the local jurisdiction. Then, Malaz, subsection 3, when the person against whom such a warrant is issued is arrested, he shall be made over with the warrant to the nearest police officer, who shall cause him to be taken before a magistrate having jurisdiction in the case, unless security is taken under 91. So if he's outside the jurisdiction of the local police station, supposing, Malaj, it's not this place, but it's say in Aurangabad or some place, Delhi, then that police officer will bring him here after arrest. Can't do that beyond the jurisdiction of this country. It's not the code. You don't have jurisdiction of people outside this country. You can follow a due process of law. You can extradite him. You can go through, if there is a treaty with reciprocity, you can bring him here. And that's the provision under 105, which your lordships will find here. Not that we are concerned with it, but just so that you have an idea. Kindly see 105? Yes. Where a court in the territories to which this code extends, hereafter in this section referred to as the said territories, desires that a summons to an accused person. So, Malaj, he says, I am an accused. So, summons to an accused person, or a warrant for arrest of an accused person, or a summons to any person requiring him to attend and produce a document or search warrant, issued it by it shall be served or executed at any place within the local jurisdiction of a court. That's right, that I'm coming to that. Then 105B, where a court in India in relation to a criminal matter desires that a warrant for arrest of any person to attend or produce a document or other thing issued by it shall be executed in any place in a contracting state, it shall send such warrant in duplicate in such form to such court, judge or magistrate through such authority as the central government may by notification specify in this behalf, and that court, judge or magistrate, as the case may be, shall cause the same to be executed. This is exactly 59, which I read to your lordship. So, Malaj, in fact, this procedure under 105B need not be followed because the PMLA has that procedure. So, Malaj, how does this magistrate pass an order that the enforcement directorate should arrest him? He can't fall past that order. And I'll tell your lordships, my lords, there are some extraditable offenses. There are some offenses which are not extraditable. So merely because, my lords, you want somebody to be arrested, if it's a summons, my lords, the Home Ministry actually gives six weeks notice. Before that, no decision is taken. So there's a whole procedure. If it's an arrest, my lords, the contracting state will decide whether it's an extraditable offense or not. Now, that also is a judicial proceeding. Mullahs, many of these people, as your lordship knows, Mullahs, are in London today. They have not been brought back because extradition proceedings are pending against them. Yes. Right, Mullahs? So those extradition proceedings are ultimately in a court of law. Then there are appeal courts. Right? And then the matter goes right up to the Supreme Court. In the UK, I know it goes right up to the Supreme Court. And ultimately, if the court finds that because you can seek asylum, there are so many other issues there, Mullahs. Now, how does a magistrate here ask the enforcement directorate to go and arrest the man? And on an application under 65, read with 70. Because he knows 70 doesn't apply. He knows 65 has no application. He knows that I could not have attended. He says I was evading. He says I'm not cooperating when there is no way I could have cooperated or attended. And then they get this order and then they say, okay, you go and arrest him. This is all lawless, Mullahs. We're governed by the rule of law. Mullahs, kindly see Article 21. Kindly see 21. I mean, this is 21 of the Constitution. This is not fair. I mean, you can do whatever you want with me, but you please follow procedures. No, it's okay. This is a commentary, no? It always has. No. It's okay, then. Yes. No person shall be deprived of his life or personal liberty except according to procedure established by law. The procedure established by law is if you want to summon a person, you have to, and if he doesn't obey, you have to go through the procedure. Right, Mullahs? If the court wants to summon, they have to go to a different procedure. If you want to summon, the consequences are 63. You can't go beyond that. Yeah. So this order is contrary to Article 21. Ex facie, contrary to Article 21. Now, Mullahs, let's move further. Now, Mullahs. No, one second. Next, to come to the next document. The ECIR. Page 60. This is the ECIR, Mullahs, which is RPZO 10 of 2022. Date is 6th of October 2022. Your lordships will see that.
Yes.
In this, they set out all the facts. And ultimately, they say, para 7.3 at page 66. Well, they set out the facts above, and they say from the above, it appears that Saurabh Chandrakar, Ravi Uppal, and others, by being involved in illegal online betting through Mahadev Book, accrued huge profits from their subscribers. And thus, prima facie, it appears that the profit accrued in proceeds of crime, which is subject to further investigation in the matter under the provisions of the PMLA. On the basis of the aforesaid information, documents, prima facie, a case for offense of money laundering under 3 and 4 appears to have been made out. this addendum to the ECIR registered and such is recorded, against which investigation under the provisions of the PMLA and the rules framed have already been initiated in ECIR 10 of 2022. Right? Then, Malats, there are some press reports which we need not go into. And the summons that your lordships will see, ultimately that they issue to me, this is very interesting, Malats, is after the 4th of September, they issue a summons to me on 13th of November, which your lordships will find at P6, which is at page 73.
Yes.
This is served on me through email, and I respond.
This has been issued on
13th of November.
13th of November.
But this case doesn't relate to this, Malats. We're not concerned with this, but I just wanted sort of chronologically you should not.
So does this summons or the ECIR have any bearing upon the impugned order?
No.
Because you are challenging the impugned order.
That's right. I'm
issuance of
no
the
bearing. But Malats,
warrant of arrest.
since it is part of the record, I just want to Malats indicate no bearing at all, because the point is very short. The point is very short.
Whether the magistrate can issue the warrant of arrest or not.
That's correct. Right. In the light of the provisions in the PMLA itself, whether they have a power under 70, read with 65, and whether, Malats, in fact, I have not cooperated. But at that point in time, their only allegation is that I'm not cooperating, that I'm willfully not appearing, knowing full well that I can't. Correct? So therefore, all these facts, they have nothing to do with the case. Right, Malats? Therefore, that's why I'm not going into any of the facts. I'm sure my learned friend will only read the facts and nothing else. But that's another matter. Now, what is the procedure, Malats, that is followed? Your lordship, in a summons, that your lordships will find at page 88. 88. But before that, kindly come to page 66, Malats. 86. It gives you the procedure of 105, Malats, but it's the same
page
procedure.
86 is the comprehensive guideline.
That's the guideline that is referred to at 59. Just kindly have a look at 59 again. Of PMLA.
59.
59. I read it. Of PMLA, Malats. PMLA.
Section 59.
Section 59 of PMLA.
Yes.
This relates to a summons issued by the court. These guidelines are, Malats, it's a summons issued by the court. Right? This is not a summons issued by the court. This is a summons issued by ED, Malats. But anyway, what are the guidelines even in a summons issued by the court? That is at 59. Section 59, where a special court in relation to an offense punishable under Section 4 desires that a summons to an accused person or a warrant for arrest of an accused person. Right, Malats? Then it says, issued by it shall be served or executed in any place in any contracting state. It shall send such summons or warrant in duplicate in such form to such court, judge or magistrate through such authorities as the central government by notification specify in this behalf. Right?
When the statute provides a particular manner in which the summon has to be served.
Yes. That is through a court. Right, Malats? Then this procedure has to be followed. And if it's the ED, Malats, summoning, then 63 has to be followed. Because if I don't obey that, provided, Malats, your lordship comes to the conclusion that I willfully did not obey, that I was willfully not cooperating, then only an order can be passed, Malats. But I started by saying, let's assume that I am not cooperating. Then, Malats, 63 is the only remedy. Because 105 and 59 are remedies when the notice is issued by the court. That stage has not arisen, Malats. That's the point I was making. But anyway, Malats, your lordships will have a look as to how this is done. That's at page 86. Section 105 of the code speaks of reciprocal arrangements to be made by central government with foreign governments with regard to service of summons, warrants, judicial processes. Ministry of Home Affairs has entered into mutual legal assistance treaties with 22 countries which provide for serving of documents. But now your lordships will see that Dubai, that is UAE, is part of this, United Arab Emirates. Your lordship sees that? So they have a reciprocal arrangement with the UAE. You'll find that at, what is the second line? Yeah, second line of the country, first line of the countries, right at the end. Turkey, UK, Canada, Kazakhstan, UAE, Russia. Lordship sees that?
Yes.
So they have a reciprocal arrangement. The summons, warrant, judicial processes received by MHA are forwarded to the concerned Indian missions. I told your lordships that, which in turn takes up the matter with the designated authority in that country. In case of MLAT countries, the manner of communication is as laid down in MLAT and can be either directly between MHA and the central authority or can be through the diplomatic channel. Designated authority, after considering the request, directs its agents to serve the document on the concerned person, and the report of its service, if any, is also received through the same chain. This is broadly the system in majority of the countries. However, in some countries, private companies have also been entrusted with service of judicial papers. Based on experience gained, some guidelines are given below, which may be followed while making a request to MHA for service of judicial processes. It may, however, be noted that it is the discretion of the requested country to serve the documents, and any time frame for positive response cannot be predicted. So, Malas, it is with the requested country, it is the contracting country that decides, and there is no time frame for them. So all requests for service of summons, notices, judicial processes on persons residing abroad shall be addressed to the Under Secretary, Division, Ministry of Home Affairs, on the 9th floor, so-and-so, through post, only with a covering letter from the Registrar Court official giving the following information.
Yes.
Material facts of the case, offences alleged to have been committed, name, designation, telephone, fax number, complete address, approval of competent authority to bear any expenditure, degree of confidentiality, any time limit within which request should be executed. MHA on request, kindly see, MHA on receipt of request will examine it in view of the provisions of the treaty, if exists with the requested country, as per the provisions of the CRPC in case of non-treaty country. India has an MLAT with Singapore, we'll leave that out. MHA requires at least period of 12 weeks time for service of such notices to the concerned countries. So, Malas, even a summons, 12 weeks are given. Here, the order of the magistrate is go and arrest him. We're not living in a country, Malas, where the diktat of the enforcement agency will run wild and they do what they like, unconcerned with the law. And how can magistrates pass such orders? Right? 12 weeks. It is therefore imperative that a date of hearing appearance may be decided accordingly. In case of we leave that out. Name and address of individual organized should be complete and all that. Ministry of Home Affairs' responsibility to service the summons is only in criminal matters. Hence, summons in criminal matters only may be sent. MHA does not undertake service of any non-bailable warrants of arrest. The Home Ministry does not take any responsibility of service, but the Enforcement Directorate will direct arrest. Means a power which are larger than that of the Home Ministry. Even the Home Ministry can't direct arrest, Malas. The service of non-bailable arrest warrants amounts to the extradition of the individual. The requests for extradition are based on certain legal procedures contained in applicable treaties negotiated on the basis of international principle of extradition. Such requests are to be forwarded to the Ministry of External Affairs. Right, Malas? So if it's a question of extradition, then it's the External Affairs Ministry, which what I told your lordship. If it's only service of summons, it's Home Ministry. And we're talking about service of summons by ED, which doesn't even apply here. Because this is a summons that comes through court. In other words, Malas, court applies its mind to the facts, comes to a conclusion that in this case, summons is necessary, gives reasons why I am passing that order, Then the matter goes to the Home Ministry as far as summons is concerned.
Yeah.
12 weeks are taken. Then through the mission, it is served on the court. Then the court then serves it on the individual, and then the service is complete. The summons issued by foreign courts authorities, that's not relevant. So, Malas, I just wanted to tell your lordship as to what the procedure is. And then, of course, it all depends on the nature of the treaty. Malas, there are some offenses that are not extraditable. For example, defamation, not an extraditable offense. Criminal defamation. There are many other offenses like that. Some political offenses, Malas, are not extraditable. Anyway, so that Malas takes care then kindly come to, I've shown your lordship the section 70 application, so that's done. Then, my lord, and where are we? Yeah, Malas, then there's the prosecution complaint. We're not concerned with it. Now, Malas, kindly see what their case is. I will just point that out. Now, Malas, that your lordships will find at page, this is Saurabh, this is reply, Malas. Reply, page number 22 of the, maybe 24, I don't know. It's 22. In their reply, page 22. Yes, let's see what their position is.
Page 22 of reply.
Yeah.
That's the affidavit, but what is the reply? Here it is. There's the reply.
22.
Give me the reply.
affidavit है.
This is the reply. Yeah, that's what I was trying to access. This is the reply, and the
Page
page is
22
at
is the
page
affidavit.
1, Malas. Page 1 of the reply.
Page
1, Malas, of the reply. Reply to the petition, Malas, under.
Yes.
Kindly see. They say, Malas, that an ECIR was recorded against Mahadev Online and others to investigate the matter under the provisions of the Act. And then they say there's a charge sheet filed by the state police, right? Then they go into the facts, Malas. We're not on that. Then they say this matter was reinvestigated. Let's leave that out. Then the role of the petitioner is set out, Malas, in paragraph 22 at page 6. And they say basically that I hail from Chhattisgarh and I have risen remarkably in the world of illegal gambling. I'm a co-owner of an illegal online betting platform. And Malas, then para 23, they say that I've been Chandrakar, along with Ravi Uppal, are the main beneficial owners of Mahadev Online Book. They're running an online betting empire through massive call centers where WhatsApp and Telegram closed groups are operated and Benami bank accounts are used to receive and pay money. They have created a pyramidal network where betting panels are franchised for a big security deposit and they keep 70% of the betting profits. They have successfully created a model in which, without coming to India, remotely they're able to run these panels with the help of large number of known Chhattisgarh natives. They've managed to lure large people. Well, if all this that we have done is what we have done, they have recourse, Mother. They should follow the law and bring us here. Nobody prevents them. But the fact is they have no evidence. But that's another matter. That's in another proceeding. Then, Malats, they give the details. Then they reply to my grounds. Now, this is important. Para 31 at page 9. They say, contents of C&D are denied. The directorate had arrested 4 accused in the case and was under a time constraint to complete the investigation. You had that?
Yes, sir.
Yes. Consequently, the directorate could not afford to grant weeks or months for individuals to respond to summons. unless a genuine reason for non-availability was provided. If the director's sole intention was to issue NBW against the petitioner, it could have done leisurely after filing the prosecution complaint. However, the director's primary goal was to conduct a comprehensive investigation in respect of the petitioner before filing the prosecution complaint, for which the presence and statement of the petitioner were crucial, and hence summons was issued to him for appearance. Somebody, I don't understand that. So they say we wanted him before we filed the prosecution complaint. That's their case. They filed the prosecution complaint. Without me, without a statement. And they say, therefore, we had to give him short notice because we didn't have the time. Well, what's that? I mean, you can't play with liberty like this. You can't say, I had short notice, so I will ask ED to go and arrest him in Dubai. That the contents of E are denied for being incorrect, that it is submitted that a summon under 50 was duly issued and served as per rule upon the petitioner. Well, what is this? I've shown to your lordships it couldn't have been. This, along with the fact that the petitioner had obtained citizenship of a small island nation, Vanuatu, which does not have any extradition treaty or arrangement with India, made it amply evident that the petitioner did not intend to join investigation. Accordingly, an application for NBW was put up before the special court, Raipur, as there were ample evidence that the petitioner was prima facie involved in money laundering activities through Mahadev Online Network. That the contents of Ground F are denied for being incorrect as it is submitted, that the law is well settled that courts have the power to issue non-bailable warrants against accused persons where they fail to cooperate and deliberately avoid the process. What does this mean? Fail to cooperate and deliberately avoid the process. The consequence of that is in 63. And in this case, I have not failed to cooperate. That relying on a decision of the Supreme Court in Dawood Ibrahim, which says, and they quote Mullah's Quattroki's judgment, which has absolutely no application. Supreme Court considered the question whether the court can issue a warrant or apprehend a person during investigation for production before police in aid of investigating agency. This question was answered by the court, holding that 673 confers the power upon a magistrate to issue a warrant and that it can be exercised by him during investigation. No doubt about it. Nobody disputes it. This is local jurisdiction. It was further held that 73 is of general application and that in course of investigation, a court can issue a warrant and exercise of power thereunder to apprehend inter alia a person who is accused of non-bailable offense and is evading arrest. On the question whether such issuance of warrant can be for his production before the police in aid of investigation, it was observed by the Supreme Court that a magistrate plays not frequently a role during investigation, in that on the prayer of the investigating agency, he holds a test identification. Well, all this is fine, but only if I am in India. It is submitted that the instant petition is legally not sustainable, since it is a settled position by this honorable court that the accused should be present in person. Of course not, Mullahs. In criminal matters, I don't have to be present. That's not the law. Submit to the jurisdiction of the court and should submit to the jurisdiction of the court for cancellation of the non-bailable warrant. Reliance in this regard is placed on the Shok Malik. First of all, warrants cannot be cancelled in absentia. But we are not on that. We are not seeking cancellation. We are saying it's void. Couldn't have been issued. It's against the law. It's violative of 21. Violative of the procedure in PMLA. It is further submitted that it is a settled proposition of law that courts have the jurisdiction and power to issue non-bailable warrants of arrest in aid of investigation. No doubt, this is a good proposition of law. When an accused is not available for investigation, despite notice at his permanent address, in a case of a cognizable and non-bailable offense to the investigating agency, and which is an offense of serious nature for arrest, even without service of notice. Sorry. The investigating agency would be within its jurisdiction to get an order seeking issuance of non-bailable warrants. Contents of, this is important, contents of K are denied for being incorrect, as it is submitted that it is well settled that a person is summoned to give evidence under 50 subsection 2. Person so summoned is bound to attend in person and state truth upon any subject concerning which he is being examined or is expected to make a... That's where we find in India, Maharaj. Moreover, at the stage of summons, the petitioner do not assume the character of an accused. But I don't understand that. This is completely contrary to what they have said, Maharaj. They said, I am an accused. Now he's saying, no, this summons is not meant, need not be for an accused. Correct. I said that myself. It can be to an accused, it need not be to an, but they don't disclose that fact to me. Vijay Madanlal Chaudhary Maharaj is in my favor. Article 20, sub-article 3, Maharaj, I am not concerned with that. I'm not even arguing that. So let's leave that out. Then, Maharaj, Directorate of Enforcement during the course of inquiry is statutorily empowered to issue summons to persons for the purpose of inquiry and seek adducing of material evidence necessary for inquiry. When summons are issued, there is a legal obligation of the person summoned to comply with the summons. Well, who disputes this proposition? I am not disputing it. It is well settled that the Director of Enforcement, that's para 39, is statutorily empowered to summon any person, and it is the consequent duty of such person to attend the same. Reliance is placed on a decision of the High Court in Amanatullah Khan. Then, Maharaj, they say it's section 50. No, we don't dispute any of this, Maharaj. Then, Maharaj, the highlighted portion, para 21 at page 14 at the bottom. It is apparent from a reading of section 50, as well as the decision in Madan Lal Chaudhary, that the power conferred upon the authorities by virtue of 50 empower them to summon any person whose attendance may be crucial, either to give evidence or to produce or records during the course of investigation. We accept this. We are talking about the procedure to summon, Maharaj. We don't deny the power to summon. We are on the procedure to summon and the consequences of my not appearing. That's what we are dealing with. The persons so summoned are also bound to attend in person or through authorized agent and are required to state the truth. Absolutely right. Then, Maharaj, they are referring to a Directorate of Enforcement, what is state of Tamil Nadu. All persons so summoned shall be bound to attend, correct? From a bare reading of the provisions, it is clearly transpired that the concerned officers, as mentioned therein, have the power to summon any person who denies them that power, Maharaj. They have a power to do a lot of things. We don't dispute any of this. Then they are talking about the money made in the app. We're not concerned with the merits. Then, Maharaj, they say, we are not concerned much. Most of this that they have quoted is wholly irrelevant to the issue, Maharaj. They say, Maharaj, para 51, they say that money laundering is an independent offense. We accept that. It is an independent offense regarding process of activity connected with the proceeds of crime. No difficulty in accepting this. Then, Maharaj, kindly come to para 295 of Vijay Madanlal Chaudhary, which is at page 19, the highlighted portion. We also accept this, Maharaj. The sweep of section 5.1 is not limited to the accused named in the criminal activity relating to a scheduled offense. It would apply to any person not necessarily being an accused of the scheduled offense, if he is involved in any process or activity, correct? Section 5 deals with attachment, Maharaj. Your Lordship may just have a look so that your Lordship knows what they're talking about. So, Maharaj, when I'm summoned and I'm prosecuted, Maharaj, under 3 and 4, then 5 says attachment of property involved in money lending. So, Maharaj, simultaneously an attachment order is passed, and that is conferred.
So this is also not concerned with the present case.
I don't know why they're quoting all this. They probably want to sound very academic, Maharaj, which is fine. And this is their entire reply is this.
Yes.
Nothing on what I have said. Nothing at all.
Yes, Mr. Saurabh Khan.
Nothing at all.
He's not connected anymore. His chamber connected with.
There are judgments, Maharaj.
Yes, please.
There are judgments. Judgment.
We'll have to get objection.
But in case my lord is wanting me to commence, or if Mr. Sibal is done.
No, not yet fully, but
Very-
my learned friend is also to argue. You can argue that. You can tell me. Okay.
I had indicated only one submission. I had indicated to Mr. Sibal.
Just a minute. Let him complete.
No, I'm not arguing, my lord. It's only a housekeeping issue. At 1:45, I have a part heard in Punjab and Haryana. I had indicated to Mr. Sibal. He was kind enough to agree
No,
that
I didn't agree. I said how can I?
No, I said he was kind enough to say that he will not oppose such a request.
No,
So-
I never said that. That's not true. I said that the court will decide. I have not said that. How can I say
Of
that I
course,
will
the
not?
court will decide. Therefore,
What do you want?
other-
What do you want?
I mean, it's for
For
the
my
court to
turn,
decide. You make that request.
Of course, the court will decide, Mr. Sibal. I'm only saying how fair you were last night when we spoke, which you're not being right now, but I'm only pointing out.
That's right. Last time you spoke, I did say yes, but not
Yes.
not to this case. In this case,
Last night when
because
you had landed.
I came. I said you make a request to the judge.
Yes, of course. So my only request is, if I'm fully ready with the matter, if my lord can have it tomorrow for my turn. That's my only request.
If Mr. Sibbal or Mr. Srivastava has no objection in that.
Mr. Sibal was very kind, my lord. He said that if the court allows, I have no objection.
Malaj, don't put the burden on me, Malaj. That's not fair at all because we get embarrassed in the process, Malaj. I don't want
No.
to.
Mr. Sibal, whenever you made a request to us, my lord, Mr. Sibal will know that.
Whenever you have also, we have already always agreed. That's
Yes.
not.
So,
That's not. An
so now
issue.
the ball is
But
in
if
your
I've come
court.
all the way and you say tomorrow, it becomes difficult for me. That's the only thing.
No,
Because
no,
I can't stay.
Definitely.
You
I
can
can't
do
stay,
it
Malaj.
over VC. My learned friend can be over VC, my lord.
I
This is
can't.
a very, very effective VC.
No, I'm sure it's an effective VC, but
The other matter is a case where the person is inside. That's the only reason. Otherwise, I would not have thought that. It's a overnight part heard, and the person is inside, and I have to respond today at 1:45 in Punjab.
the problem is, Malaj, that tomorrow I have to be back for committed matters, and 18th I have to argue before the PMLA bench, Malaj, challenging the Vijay Madan Lal
No,
Chaudhary
I'm not
matter.
seeking. I'm not seeking a long
So
date.
how much time you will take?
My lord, I'll take maybe 5 minutes less than what Mr. Sibal has taken.
Because right now I am having half an hour.
Half an hour I can argue, my lord. Only difficulty 1:45. The bench, my lord, is hearing an overnight part heard. That's the only request.
What I point to was they took the decision to arrest. And 90 will apply according to this.
Or
Two
Mr.
other
Sibal may
parts.
continue.
Yeah, I'll continue, and then the learned judge will decide, and whatever your lordship says, when I'm not going to say anything on this.
He
That's your
wants to
lordship.
continue his argument by tomorrow.
The point is that I am busy tomorrow.
Yes.
This is my
Definitely.
problem. And then day after, I am busy, Malaj, in that PMLA matter. I have to open the case. My learned friend knows it. He's going to be there too on the
No,
other side.
that's on the 18th, Mr. Sibal. Day after is 13th.
13, as you know, I'm already committed, and then there are holidays. 14, 15, 16 is holiday. As you know that. That's the what? Eid is 16th. Huh?
My learned friend will conclude, my lord, today. He can conclude today.
So what I'll do, there are two matters, Malaj.
Yes.
I'll complete my argument. Let me do it today itself.
Yeah.
Anything is left, my learned friend will do it. Malaj is
Yes,
the other matter.
please.
At least let me complete.
Yes.
And then he can do whatever lordship,
If I would take this matter tomorrow,
yes.
as on the request of Mr. Sen, then are you able to
Tomorrow itself.
answer the?
That'd be difficult, Malaj, because I'll have to be, because I'm already committed in matters. That'd be difficult because I won't be able to hear what he says and how.
Then I have to put the matter for in any other day.
But let him argue tomorrow, Malaj.
Yes.
At least if
Yes.
that's the case, let him argue tomorrow that he finishes.
Yes.
Then, Malaj, your lordships may give me a time so that I respond.
Yes.
That's all I can say, Malaj.
Yes.
Fair
Nothing
enough.
more.
Yes.
That's very
all
fair.
right?
Yes.
Fair enough.
Yes. Now, Malaj, now the two other points.
Yes.
Kindly see section 61. PMLA. 65(1). CRPC. CRPC 65(1).
Hmm.
65, that if service cannot be, by exercise of due diligence, be effected as provided in 62, 63, and 64, serving officers shall affix one of the duplicates of the summons to some conspicuous part of the house or homestead in which the person summoned ordinarily resides.
67 is the service of summons outside local limits.
Yes, that's local limit of the police station.
Yes.
Right, Malas? We're not local limit, not outside the limit of the country, Malas. So these all summons are for summoning people who are within the jurisdiction of the court or outside the jurisdiction of the court, but within the territory of India. So therefore, 61
In the
says,
territory of India.
yes, right. That has to be, Malas, because our summons will not
Yes.
will not operate outside our territory. So 61 says every summons issued by the court shall be in writing in duplicate signed by the presiding officer from time to time.
So all these are the procedure for
Procedures. Summons house served, service of summons in corporate bodies and societies, service when person summoned cannot be found, correct? And then procedure when service cannot, as provided, as before provided. So if service cannot be, by the exercise of due diligence, be effected as provided in section 62, 63, or 64, serving officer shall affix one of the duplicates of the summons to some conspicuous part of the house or homestead in which the person summoned ordinarily resides, and thereupon the court, after making such inquiry as he thinks fit, may either declare that the
And
summons
this exactly has been done by the ED.
I'm sorry?
This exactly has been done by
This is what
summons has been affixed in your,
but I don't ordinarily reside there. They know I'm not even a citizen. There's no question of my ordinarily residing there, Malad.
yes.
Admittedly, Malad, I don't reside there. It is their case that I am in Dubai, Malad.
You are at Australia, at that point.
At that time in Australia, now in Dubai. And I'm earning all my
Yes.
profit sitting in Dubai. So how can they serve the summon here under 65? And this is only when I am available in India. I can't be found in India. I have gone underground. Then they will affix it and that service will be deemed to be complete. It cannot apply to a person who is outside the territorial limits of India. Unless that's India is his normal place of residence. That's clear, Mother. Right? So therefore, that doesn't apply. That's one of their...
Give your judgments.
I'll just, well, the second thing, quite frankly, judgments are modulated around the facts.
Yes.
We always say that, because that's why law is such a exciting profession, because every time you have a case, there is something new that arises. Now, let's kindly have a look at section 19 of PMLA. That's also very important.
19.
19. It's a very interesting provision. If the director, deputy director, assistant director, or any other person authorized in this behalf by the central government is by general or special order has, on the basis of material in his possession, reason to believe. The reason for such belief to be recorded in writing that any person has been guilty of an offense punishable under this act, he may arrest such person and shall, as soon as may be, inform him of the grounds of arrest. So the power of arrest here is given to a director, deputy director, assistant director, or any other person authorized. That is why my argument that these are police officers was rejected. My argument was, in Vijay Madanlal Chaudhary, their powers of search, seizure, survey are all the powers that are concomitant with the powers of an officer of a police station.
Yes.
So even though they are designated authorities, they are actually police officers. Court has rejected it, right? But the power to arrest is inherent in these officers. And to arrest a person, you have to record reasons in writing. Now in Pankaj Bansal recently, Supreme Court has said that those reasons have to be communicated to the person at the time of arrest. So the procedure for arrest is in 19. In 19, Malas. This 19 is inconsistent with the Code of Criminal Procedure. So to the extent 65 says, to the extent of its inconsistency, PMLA will apply. So a police officer cannot arrest the man. This has to be done by him. But they don't have any, they have not passed an order of arrest, Malas, against him under 19. They have not passed an order of arrest. There are no reasons. They accept the fact that there are no reasons. But they are following the circuitous procedure in order to just get rid of the law. They are seeking my arrest, Maharaj, without 19, without reference to 19. And they are seeking my arrest on what ground? That I have not obeyed the summons deliberately. Where's the power? But that power is not here, because this says I'm guilty of the offense. There according to them, I'm guilty of not responding to the summons. These are two separate powers in law. It has nothing to do with the offense. That power, my allegedly disobeying the summons, is nothing to do with the law, with the grounds of arrest, or my culpability in having committed the offense. It's nothing to do with it. That's not their case. At least, Maharaj, in moving that application under 70. That's not their case. So the power to arrest is given to these authorities. They are not seeking my arrest on this ground. They are not saying I'm guilty of the offense. They are saying that I have not obeyed the summons, but I will arrest you, and the ED will arrest you and execute that without reference to any law. So I just wanted to just clarify these 2 points. Now quickly, Maharaj, the judgment. Yes. Now let us kindly see. State of Jharkhand versus Ambe Cements, 2005. I'm sorry, Maharaj. State of Jharkhand versus Ambe Cements, 2005, 1 SCC, page 368. At page 378. Para 26.
Para?
26.
Yes.
Whenever the statute prescribes that a particular act is to be done
When the particular act to be done in a particular manner, that it has to be executed in a particular manner.
That's correct.
In that particular.
That's why I made this submission.
Yes.
This applies to a penal statute also. It is the cardinal rule of interpretation where a statute provides that a particular thing to be done, it should be done in the manner prescribed and not in any other way. It is also settled rule of interpretation where a statute is a penal in character. It must be strictly construed and followed. Since the requirement in the instant case of obtaining prior permission is mandatory, therefore non-compliance with the same must result in cancelling the concession and made. So it has to be strictly followed.
Yes.
You can't devise a procedure which is unknown to law, which is what they've done. And Panchat Bansal. There's a compilation which we've given. Give me what judgment. Give me what's it. Yeah, tell me. Yeah,
This judgment compilation.
well, it's not here. You don't give it. There is a. Give the hard copy to my lord. There, yes, sir. Para 25 of Pankaj Bansal. $143. Okay, so you give it to me. This you keep. Give me the hard copy and tell me. Yes. You tell me the paragraph. 25.
Paragraph number?
25, Malas, at page 150, 156. This is on section 19. I read section 19 to your lordship. It's not 25. 30, 30, Malad, page 157. In this context, reliance is placed by the ED upon the decision in the division.
But at 29 onwards.
30?
29 onwards.
29 onwards. That's the most important issue presently as to how the ED is required to inform the arrested person of the grounds for his or her arrest. Prayer in the writ petitions filed by the appellants pertain to this section. 19 does not specify in clear terms as to how the arrested person is to be informed of the grounds. Anyway, Malas, what they've held in 2930 is that you have to now inform him of the grounds of arrest. The reason is simple, that how do you ask for bail? Malas, if he's not informed of the ground of arrest and I'm arrested, Malas, as your lordship knows, under the code, there's an FIR. I know the allegations in the FIR. So I know what the case against me is. But under 50, I don't know. You're calling me. I don't know what the case is. I don't know whether you're calling me as a witness. I don't know whether you're calling me as an accused. I don't have the grounds of arrest. So when I'm produced before the magistrate within 24 hours, how do I argue my bail? So therefore, the court has now held that you must simultaneously at the time of arrest inform me of the ground of arrest. Otherwise, Maras, the law was that the grounds of arrest would be to send to the magistrate in a sealed cover and nobody was to be informed. So the court, Maras, in Bansal has said, no, that's not correct. Otherwise, I can't exercise my power, both, Maras, for bail, but even otherwise under Article 20, I am entitled to the grounds of arrest. That's para 36 and 37. Your lordships may note that. Then what else? Which other judgment? What is the reason why I don't quote judgments is, Mullah, because the judge makes the law, Mullah. Judgments on the
Judge makes the law on the basis of facts and judgments.
no facts. Principles are set out in judgments, but Mullah's facts may vary.
Guidance from the previous judgments.
Yes, but Mullah, this will never. This is never
of the facts of the.
But this has never come up before, Mullah.
Yes.
This issue has never come up before. Because before, Mullah, occasionally the ED acts in accordance with law.
Yes.
But Mullah, sometimes they don't. I'm deeply obliged to you, Lordship. Grateful.
Thank you.
Your Lordship may pardon my absence then, Mullah.
No.
And I'd seek your indulgence after years.
Yes.
I have a very small offer, my lord. In case, since Mr. Sibal is here, I wanted to present it to him. And this is without prejudice to all the legal submissions that I have made. Please have, my lord, an order where the Delhi High Court had also formulated a very similar sort of a option to the person who was abroad not joining investigation. Please have that order, my lord, of Sumit Chadda.
So are you opening your argument, Mr. Sen?
I'm only making, because I'm told that my other learned senior has to also argue, who's along with Mr. But since I wanted to have the benefit of Mr. Sibal's presence, physical presence, I just wanted to make this offer so that the whole controversy may be set at rest. Please have this order, my lord. It's an offer which Mr. Sibal may choose to refuse, but it will be difficult to refuse. Please have para.
Go ahead. I don't want to say anything. Go ahead.
Please have para 7, my lord.
Yes.
However, Mr. So-and-so learned special counsel for ED on instruction submits that in the peculiar facts of the case, NBWs may be suspended till the next date of hearing. And in case the petitioner joins the proceeding before the trial court in the month of August 2024, as undertaken by him, NBWs may be cancelled thereafter. So my lord can suspend the NBW, let him join the investigation.
But subject to.
Of course.
This
It's
is
an offer.
sugar-coated quinine.
It's an offer which my learned friend may choose to deal with.
Sugar-coated quinine, Marat. Right? So therefore, let's take off the sugar.
Yes.
Don't administer the quinine to me, Marat.
I'm
so,
reminded
that's
of
rejected. That offer is rejected.
I'm reminded of Roger Moore, an offer which you will find hard to refuse.
Well, that's not, I mean, there's an offer that I might find hard to believe, but not with reference to Roger Moore.
Very well. So I wanted to place this. My learned friend does not want to come and join investigation.
Yes.
Fair enough. So
apply.
Malord may only take, whenever Malord passes the judgment, Malord may take note of this fact.
Yeah,
that
that's fine. We'll
the ED has a bona fide offered him to come back
That was
and
a
even
valid
offered
NBW. This is a NBW with
That-
no authority of law.
that my lord will decide
That is the difference.
after hearing me.
That's a difference. So you argue that.
Yes, yes.
Yeah.
Obliged, I'm deeply obliged.
So other matter, my lord, I will be arguing tomorrow.
Yes.
And can I just pray, my lord, your lordship's indulgence? Similarly, my lord, after the my lord fresh matters.
I can't say because all other matters are held up.
Hearing has started. It's better that it is concluded. It will be fresh
Certainly,
in your-
certainly.
It would be fresh in your lordship's
Hmm.
mind.
No, it would be better for all of us.
Yes, my lord.
It would be better for all of us.
I agree.
After the fresh matter and urgent matter, so lordship may take up this matter, my lord.
कल list में आ गया इनमें. We will take a chance because it depends upon the listing of the matters. How much matters is to be listed in the fresh matters are. Let us take a chance tomorrow.
Yes, very well.
Let us
very
take a
well,
chance.
very
Obliged, my lord.
Both these matters बोल दें दोनों कल के लिए. Mr. Himanshu, please give a chit for appearance of this. ये दोनों मैटर को कल के लिए लिस्ट करेंगे.
Deeply
By tomorrow.
Yes.
Deeply obliged.
Yes.
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 ये भी उसमें लगा.
May I be excused, ma'am?
Yes, please. Thank you. हम की बातें करेंगे. और कौन सा है? लिस्ट 2 होगा ना. चालू कर लो. Yes, Mr.
I'm really sorry, मैडम. ग्रैंडसन की तबीयत बहुत ज्यादा खराब थी, उसको डॉक्टर लेके Lord, I'm saying that MSc number 52/2017, which was dismissed on 22/8/2024, as I was not present, the matter was taken up for hearing.
कहा कि आपके अपोजिट काउंसिल नहीं आए? देखिए मिस्टर
That on 23rd of July, the wife was admitted in Raipur as she suffered grievous injury in his right ring finger. So there was no any hand to look after her.
ये तो 22/8 का है.
Ji, he was continuous admitted there.
Mr. Raj Awasthi, the net counsel for the applicant, none for the respondent. This is an application for restoration of the miscellaneous appeal C number 53 of 2017, which has been dismissed for want of prosecution on 22/8/2024. Next, the net counsel for the applicant would submit that due to unavoidable reasons, he could not appear before this court when the matter was called for hearing. Therefore, the miscellaneous appeal C number 53 of 2017 may be restored in its original number and may be heard the appeal on its own merits. Next, on due consideration and for the reason mentioned in the application, the same is allowed. The MSC number 53 of 2017 is restored in its original number. List the after restoring the MSC number 53 of 2017, list the case in the next week for final hearing at motion stage.
My lord, may I pray, one more connecting matter is there. It is yet to be listed for restoration. As
तो रिस्टोर नहीं हुआ है ना?
जी,
तो रिस्टोर होगा तब ना जोड़ेंगे.
तो मैं आफ्टर 2 वीक इसको कर देते इन द मीन टाइम वो भी.
तो इसको वो वाला लास्ट सेंटेंस मत डालना, फिर रिस्टोर्ड बस डालना बस इसको. लिस्टिंग का मत इसमें डायरेक्शन करना. ठीक है, रिस्टोर्ड इन इट्स ओरिजिनल नंबर. ठीक है, नहीं सर.
Much obliged.
The MCC is disposed of.
Much obliged.
Mr. 2, Mutterani letter, sir, item 1 and 2. Shri Prasun Agarwal, Madam Aditi Singhvi, Shri SP Sahu, AG.
If I appear in item number 1, there are two connected appeals.
Yes. Who is in item number 2? यानी 2 नंबर की फाइल कौन है? ये कौन है? प्रमोद राम टेके, पी चेतन कुमार. बुलाना इनको तो. कौन है प्रमोद रामटेके? नहीं, उनका लीगल एड से उनको मिला है, अपीयर ही नहीं हो रही है। यस मैडम।
सर इसमें फर्स्ट नंबर के लिए मैम सर इसमें लीगल एड से मेरे को
कौन सा फर्स्ट नंबर के लिए?
ये दुर्गेश
दुर्गेश के लिए तो मैडम अपीयर हो रही हैं।
लीगल एड से मिला।
Lordship, it was alerted to me by memo dated 18/8/2023.
दुर्गेश के लिए तो मैडम सिंघवी को अलॉटेड है। बताइए, आपको पहले मिला था 19 में, व्हेन यू हैव फेल्ड टू अपीयर द केस वाज रीअलर्टेड टू मिस सिंघवी। बताइए, आप तो अपीयर ही नहीं हुई 2020 में, 2023 में, देन द मैटर वाज अलॉटेड टू मिस सिंघवी।
जानकारी
फिर नहीं है। पासवर्ड करने दूसरा पासवर्ड में रखते हैं, लेते हैं।
Lordship.
Item 3, श्री अनूप मुजुमदार, श्री कुणाल दास, श्री बसंत देवांगन,
वो
please.
मैडम मनीष शर्मा जी तो मेंशन किया था।
My lord, my
Mr.
lord,
Sharma, just a minute. Mr. Sharma, you have also mentioned before the 130.
actually, we have filed the reply.
Huh.
I had talked to the petitioners council.
Huh.
They wanted to seek time for rejoinder.
Any fixed date may be given, my lord, in the next week?
वही मैं देख रहा था, आप बैठे हैं, मेंशन किया था आपने।
नहीं, I thought कि after this list 2, at the end of the list 2, it is listed.
Sure.
I was waiting for that.
फिर अपील चालू हो जाएगी तो फिर टाइम लग जाएगा।
हाँ नहीं, मैं सोचा कि लिस्ट 2 का आखिरी में ही है और लिस्ट 2 का मेंशन वो चल रहा था, पास हुआ।
लिस्ट 2 में क्रिमिनल विल फाइनल हियरिंग एट मोशन स्टेज है।
अच्छा, that I missed. That I missed.
In that condition, you will have to.
I will have to wait for 4 o'clock.
आइटम नंबर कौन सा है?
12 and 30.
12 and 30.
Mr. What is your good name?
Mayank Goyal.
Mr. Mayank Goyal, learned counsel for the petitioner. Mr. Manish Sharma, learned counsel for the both the respondents.
Yeah.
Respondents. Learned counsel for the petitioner would submit that. कब फाइल किया आपने?
Reply today.
Today morning.
Today morning.
Learned counsel for the petitioner would submit that today itself they have received the copy of the reply filed by the respondents and prays for some time to file their rejoinder.
Next week, not any fixed date may be.
List on the request made by learned counsel for the petitioner, list this case after 2 weeks.
Lord, there's an outside counsel engaged in.
आने दिए outside है तो क्या हो गया? Yes.
Obliged. Both the cases.
दोनों में हाँ 12 और 13 दोनों में करना है.
My lord has been appeared for the state in this, the bail matter of this case in 2006, my lord.
Yes, इसको
It lies
exception
alone.
इसमें लिखना list before another bench in which I am not a member. इसको exception कर दें.
Obliged, my lord.
Item 4, Sri Rahul Mishra, AG.
Yes, Mr. Rahul.
In this case, there are two appellant, One is, has been convicted under section 363 and 366. And appellant number 2, has been convicted under section 368, Though the appellant number 1, has been acquitted under section 376 of IPC,
यस मैडम, एक नंबर में ना, सीरियल नंबर 1 में मिस सिंघवी के साथ.
Yes, Lordship. Lordship, shall I inform her?
यस, नो प्रॉब्लम. लिखना मिस अदिति सिंघवी थ्रू वर्चुअल मोड along with मिस क्या शुभ नाम, मिस स्वेच्छा शर्मा लर्नेड काउंसिल फॉर द अपीलेंट, मिस्टर कमलजीत सिंह सैनी पैनल लॉयर फॉर द स्टेट. लिस्ट दिस केस along with criminal appeal number 540 up to 106. तो ये करना, ठीक है. अब नंबर 2 में डालना, 2 नंबर की फाइल देना. None for the appellants in 2 rounds. Mr. Kamaljeet Singh Saini, panel lawyer for the state.
Lordship, item 2 में सच्चिदानंद यादव.
Item 2 में
सच
अच्छा, what is your good name?
सच्चिदानंद यादव.
Mr. Sachidanand Yadav नाम है number 2 में for panel for the state. On next, on 10/8/2023, when no one appears on behalf of the appellant, the matter was adjourned and High Court Legal Aid Committee was directed to appoint any counsel for the appellant in the case. On 23/8/2023, the memo of appearance on behalf of the appellant Dinesh Kumar has been filed by Mr. Pramod Ramteke, advocate, and Mr. P. Chetan Kumar, advocate. Along with their memo of appearance, a copy of the legal aid acceptance order dated 17/8/2023 has been filed, in which it appears that the case has been entrusted to Mr. Pramod Ramteke, advocate, as the counsel for the appellant Dinesh Kumar. But neither Mr. Pramod Kumar Ramteke nor Mr. P. Chetan Kumar, advocates, appeared in the case when the matter was repeatedly called. Next. In such situation, the High Court Legal Services Authority is directed to reappoint any other counsel in the case on behalf of the appellant Dinesh Kumar. List this case in the next week. List this case in the next week. नेक्स्ट वीक सुनते हैं, उनके कोई काउंसिल आए नहीं है.
लॉर्डशिप obliged.
पी चेतन कुमार को कोई केस नहीं अलॉट करना ना, तो जब आएगा तो बताना फिर उनको.
Item 5, Madam Meera Jaiswal, Madam Anita K, AG.
NDPS had been. ये भी एक्सेप्शन हो जाएगा। ये भी एक्सेप्शन कर देंगे इसके लिए। List before another bench in which I am not a member. ये भी एक्सेप्शन।
Item 6, Shri R.K. Jaiswal, Madam Ranjana Jaiswal, Rajkumar Gupta, AG.
नहीं, क्या है एज का डॉक्यूमेंट?
सर दाखिल खारिज जब्ती हुई एग्जिबिट P5
दाखिल खारिज
PW3 से टीचर है।
टीचर है
जी।
ऑथर है। स्कूल रजिस्टर।
जी।
और कितने दिन रही है?
सर ये 15/3/2005 से 19/7/2005
साथ में रहे
सर
हैं।
शादी भी कर लिए थे और एज पर द डॉक्टर
शी वॉज कैरिंग प्रेगनेंसी। एज पे ही है फिर पूरा। एज पे ही है।
17 years 7 months
What is good name?
Monica Singh.
Miss Monica Singh, learned counsel for the petitioner. Mr. Ajay Kumrani, panel lawyer for the
No, Lordship, respond number 224.
respondent number 2 to 4.
Yes, Lordship.
The counsel for the respondent number 2 to 4 prays and is granted 2 weeks time to file reply.
Yes.
This case immediately after 2 weeks.
Obliged.
Highly obliged.
हाँ 8 नंबर मिस्टर कहाँ गया वो मयंक चंद्राकर वाला उसको फिर मिस्टर मयंक चंद्राकर नहीं मिस्टर आकाश पांडे रेजिडेंट काउंसिल फॉर द अपीलेंट मिस्टर कौन थे इधर से रेस्पोंडेंट स्टेट के लिए
मैं हूँ।
आप मिस्टर अजय कुमरानी पेनल फॉर द स्टेट मिस्टर विकास श्रीवास्तव रेजिडेंट काउंसिल फॉर द ऑब्जेक्टर. ड्यू टू पॉसिटी ऑफ टाइम नहीं बस मत लिखो फिर उसको लिखो on the request made by land council for the parties list this case after 2 weeks.